Go, we are live.
Welcome. Good evening, everyone. From I am Rudolph D'Souza, your host today. Welcome to MyNation Hope Foundation webinar and Men Ki Baat. Today we have a special guest with us. So far we are hosting men only. Okay. Today one of our sister agreed to join us, and we want to show the world how the laws meant for women are harassing other women. Okay, so that shows how loosely these laws are drafted. Without thinking, same law supposed to protect women are abusing and harassing other women. As per NCW, only daughter-in-law is woman. If sister-in-law of a husband, her husband, or mother of a man approach them, they will not respond. That is the situation in India and in our legal system also. Here with us, our sister today. She will tell her story how our system harassed her and what problem she faced with the law supposed to protect her. Uh, I'll ask our sister to introduce herself. Madam, please introduce yourself.
Yes, being in a responsible position, first I just want to to have some disclaimer. I don't want to disclose any of my details because it is going in live now. So, introduce myself. I am just a sister-in-law suffering with 498 case from last 3 years. Being in India, that's what I want to introduce myself.
Okay. Who filed case on you and which case?
This is nothing but who else can file. It is a daughter-in-law, my brother's wife.
Okay.
It's a 498A case,
Okay.
498A, 420, 3 and 4 DP Act. She has filed on us.
Mm-hmm. Okay. Any of your family members included in this case?
Everybody. She didn't left out any person. So we are just brother and sister and husband and wife that we are living with the parents.
Mm-hmm.
So she has included everyone in the family. So it's
Okay.
everyone.
Okay. How long this marriage lasted?
See, it has happened. Marriage happened in 2016, and it has even last for only just less than a month. It just less than a month.
Okay. So how
That's it.
come she included everyone?
She included everyone. Yes, because we are living in a city. She is from a village. So because we are as a combined family, we are living together here. So
Joint family.
she joint family. See, basically,
Mm-hmm.
my parents are dependent on me.
Mm-hmm.
So we are staying together. My parents, they came from my native place to stay with me, and my
Okay.
husband, myself. So they came to me to stay along with me, and that's where when marriage happens, because that is a very newly marriage. So
Mm-hmm.
it's only one brother I have. So they
Mm-hmm.
just thought that until he settles in life for some short duration,
Okay.
so they will also stay with me. So that's where
Okay.
after marriage she came and stayed with us.
Okay. That means you try to help them. So instead, getting thankful to you, she filed case on you.
Exactly, that's correct,
Okay.
absolutely.
Okay. What was the reason she filed a case on?
Okay, so if you look at my family, so we are also basically some hardworking family that we came from. My dad is in police department.
Mm-hmm.
Though he was initially in his like 50 years back, he was a poor guy and he built up his family by working in the police department for like 30, 35 years of service, and he got retired.
Mm-hmm.
So I basically rank holder student. So basically, I got in very good position. So I'm a working
Mm-hmm.
woman professional here in the
Yeah.
city. So
Mm-hmm.
it's like we are just two members in the family, and my parents are dependent on me. So if you look at my family, it's like biggest source of income that earning right now is me only. So that's
Mm-hmm.
where so you feel like an ATM card is me. So head of the family
Okay.
or the ATM card, the biggest source of income is me, and all my properties, everything is on my name. Basically what I
Mm-hmm.
earned from last 10, 14 years of my life. All properties, it's on my name, being a working
Mm.
woman professional. So everything, so it's like it's a one single source of
Yeah,
income, big
that
chunk
means
of
if she trap you, everyone will be trapped with
everyone.
that.
See, if you my example was, if you hold for a snake or for a human body, let's say if you hold the neck or head, what you are going
Yes.
to do with the other
Yes.
parts of the body?
Yes.
You do nothing, right?
So
Once the
that
head
means it's
is
a
gone.
well planned plot.
Correct, correct. So that's where
Okay.
she trapped me first in this case.
Mm-hmm.
Every other
Okay.
person is like a side characters. I am the
Mm-hmm.
main character in my story. So it's a
Mm-hmm.
fortunate or unfortunate that I would say, but yes, it is very unfortunate. Being an appreciated person, that I'm being a woman, that I'm bringing up my family, taking care of the responsibilities, whole responsibilities on my shoulders.
Mm-hmm.
I trapped in this false case. Yes, it is going
Has she
on.
filed case on her husband or no?
Yes, it is. That's what I'm saying. It's a complete family she has filed.
Mm-hmm.
Husband,
Okay.
parents, everybody
No,
is like a side.
sometimes we have seen sometimes that she is not filing on husband, but she is filing on other family members. Okay, here
No,
she
no.
filed on whole
Whole
everyone.
family.
Okay.
It's everything, and no one left out in the family. Everybody she filed, so that
Mm-hmm.
everybody can run from pillar to pillar, corner to corner. We can run,
Okay.
and we can
Post
just
pillar.
bend,
Okay.
and then yes, we can do that.
Yeah. So the police did not do proper enquiry.
See, actually, let me tell you, the police came in after filing the FIR. They have called us for some talks, and then they said that it's a woman centric. See, my father is in police department. First, basically, let me clarify that. Though he is
Mm-hmm.
in police department, he we I mean, police couldn't able to help us because they know
Mm-hmm.
that it is a false.
No,
And
it's not helping. Okay, we are not we are not asking to help us and
correct,
save
we are
us
not
when we
we are
are
not asking for a
criminals.
help,
Okay,
but
to
but
do proper justice.
to do proper justice. Yes, once she filed the case complaint, and they know that it is a complete false case, and they came
Mm-hmm.
in after putting up the FIR charge sheet. They have done the inquiry. They came to my house in the city. They have done the inquiry with the neighbors, but then what
Mm-hmm.
happened is they told us that they cannot help us because with the woman centric laws, you go and see, come out with the clean hands in the court only. That they whatever she says, they are going to put up the case, they are going to file the charge sheet, they are going to write.
It's not like that. It's not like that. Police has to do proper enquiry because there are other judgments also where court charge police for not doing proper enquiry and investigation. They want to wash their hands immediately, filing a charge sheet without doing proper enquiry. That's the thing happening in India because they don't want to take any risk. Sometimes they are taking money also. We don't know what they did in
We
your case.
don't know. It's a case to case
Mhm.
basis. They might be
Yeah.
taking money or not. I'm not aware of that part of the story when it comes to police. But me being in my father is in the police, but they are like helpless. That's what I understood with the system and the law. That's what my
Yeah.
opinion on on this. I don't have any negative thoughts because I have not experienced personally though. But
Mhm.
yes, this woman centric laws completely ruined a family is what I can say.
Yeah. When you say woman-centric laws, this law should help you also. Or at that time, if you filed any case on her, our police will take this your complaint.
See, if you look at 498A, see what are the law provisions that is there for the woman centric when it is comes to a family matters. I'm not talking about sexual harassments or the rape or murder or this kind of woman centric laws. Let's talk about only the family centric laws. Family centric laws,
Mm-hmm.
you have 498A, DV,
Mm.
maintenance,
Mm.
125. These are the specific set of things that is protected, that is designed, the law is designed for protecting especially daughter-in-law. Now tell me
Mm.
which law is there to protect mother-in-law and sister-in-law? There are provisions to file DV on daughter-in-law. Now the point is you have to go to the court. How many
Mm.
judges are coming forward? How many cases? First of all, system is accepting. See, system comes everything, even our society. System is completely. It's a package. That's what I understood. It's not just the law. It's a complete
Mm.
system package. Means you will have your neighbors, you have your police, you have advocates, you have lawyers, you have your society. Everybody is in the system. So system, how much is accepting the DV from father, from a mother-in-law and the sister-in-law? How many cases has been filed from mother-in-law and sister-in-law? Because the judge has
Yeah,
to accept this one,
that,
right?
that is
So
clear.
that's
That is
where
clear.
that,
Tomorrow, if you are writing to WCD or NCW also, they will not take your case. Okay, they will not take your complaint. We have evidence that they straight away on the face of world woman, they are saying you are not, your case is not coming under our mandate. They are saying shamelessly, then why they are getting 50,000 crore per year in the fund. So you have right to question the WCD and NCW.
we-
Where is my
so that's what
law to
my
protect
question
me?
was. What protection is there for
Mm.
mother-in-laws and sister-in-laws? That's where my
Yes.
question. What provisions are there in law so that we
Mm.
will be protected? We are also a
Yes.
woman. Daughter-in-law
Yes.
alone is not a woman. We are also a
Mm.
woman. We are in 21st century. Let's
Mm.
forget about daughter-in-law is innocent. She will be tortured every time in the house, in the matrimonial house. Let's forget about it. It's a 21st century. Time has been changed, technology has been changed. Now our people mindset has to change now that we are also women. See, we are not living in some 50-year-old backside. Our previous generations where, yes, I agree that earlier women laws has been made to protect women because at that time suffering is more. I agree because I seen personally in my parents, grandparents lifetime how they have suffered women. I agree with that, but things has been changed. Now this law needs amendment is what I strongly believe. Once I fall trap into this case,
Mm.
I'm not against the law, the women centric laws. Yes, they have. See, if you go and go into corner villages or maybe in some parts of India where male domination is more, I'm fine. But it's not that entire India people are like that. Entire men are not like that.
See, it's
Entire
not a male dominated or woman
female,
dominated or
correct. That's what my
matriarchal. It's not like that. Law should not be biased against any gender.
exactly
Okay, when
my
the
point was
law is drafted, it should be, if there is any loopholes, if there is any misuse factor and there is a report of misuse, then our legal system, our law minister, our government, our whatever ministry, they have to try to
correct,
amend this and fix the problem, fix the loopholes.
correct.
But
My
here,
my
uh,
Correct,
yeah.
Rudy. So my point was is this one only. You have
Mm.
created woman-centric laws to protect the daughter-in-law. I'm absolutely fine with that thing. So if there
Mm.
are loopholes, if there is a misuse, let's look into that one and start amending the laws. Let's protect the
Mm.
woman who is suffering with the another set of humans. The daughter-in-law is one set of category of women. There are another set of category of women who is mother-in-law and sister-in-laws. They are also
Yeah,
women. So
that means
let's make some amendments.
daughter-in-law is one third. There is a two-third are the sister-in-law and mother-in-law. Okay, so
Correct.
it
Protect
should
them
be.
also.
Yes, and now is the one third of the women are protected, but two-third are ignored.
Correct.
And this,
Correct.
whatever domestic violence or whatever women-centric laws are there, they should be amended and fix the issues. Our law ministry and government should wake up from the slumbered, sleeping state and do the changes in system. That's what we want.
Exactly.
Anyway, this case, how even she claimed that they gave dowry, and did she produce any proof for that?
See, let me clarify. They are from a extremely poor background family. Okay.
Mm-hmm.
So let me explain the story also once it comes with questions and answers. So there is no single proof of evidence has been submitted in the police station. It
Mm-hmm.
just everything is oral. Just their parents and
Okay.
herself, with just with some villages, they'll have some villages gathered together. Oh, my daughter has been so in the village they'll have the sympathy created. Oh, one girl life has been spoiled, let's go to police station. So this sort of
Mm.
scene has been set it up, and then without any evidence they just came in orally, they said everything orally.
Mm.
They, and that
No,
also in the
still, police has to do proper investigation. So you can go to High Court, and if there is no evidence, even you can charge the police why they properly not inquired and did proper investigation. Anyway, that means whatever her claim is totally false. There is no proof in anything that
not a single
attract
proof.
498.
Correct, not a single proof
Okay, okay.
that they
And
have
this
submitted.
case, how it impacted your life? Because as a woman, and a woman is against woman, so we want to see how it's impacted your life.
See, first of all, um, if you look at my case, I am the sole earner of the family, which I am taking on my shoulders the responsibilities. My husband is
Mm,
helping me in the sense we both together is like saving my parents, their parents, and my
mm,
brother. So because just
mm,
we are just two alone, just because that
mhm,
I have my love marriage, so my husband is fortunately I'm very lucky to have him, that he supports me in every aspect of my life, whatever the ups and downs it comes into. Even from last
mhm,
3 4 years, whatever is happening in my brother's life that is impacting me, every minute by minute he is standing next to me. That's where I could able to um, fight with the system. So when the moment we see that all allegations is centered about me, first thing
mhm,
itself is like I got shocked with the allegations that it has been made. And see, I'm a woman, so I have my family. I have to take care of my family, my parents, my husband, my son, and I have to run my work also, because I'm a woman working professional. So with all this in mind, now imagine I have to go to court, every court hearing I have to go, and every police station hearing I have to go, and the society. Now I am very active woman who participates in public speaking, public talks, all these things. Now
mhm.
how my neighbors, what is the perception that they have the picture of me before this
Yeah.
case? What is the impact of me? She is like a woman empowerment lady, she is doing this sort of things, all these activities
Mm,
what I go in public, they know, my
mm.
neighbors know, my work people know, everybody knows.
Everyone knows.
So now
Everyone knows. The
after this,
society knows.
once, correct, once with this picture in mind, now imagine she came in like less than a month, she stayed in my house and she filed a
Mm,
case. Police came in, police started investigating, and then all the neighbors they have inquired because of such allegations. They are forced to inquire to my neighbors also. Now,
mm,
now imagine the picture of me being a respectable woman in the society now changed to the accused criminal person. How
mm,
is that trauma that being a woman? See, I'm not it's very easy to say that okay, all are undergoing these test cases, you just need to forget about it. It's not like that. The trauma that I have
mm,
undergone, I have not even spoken to my husband, my own father, my own, except my
mm.
mother. I have not even spoken to my family members for at least an year, because I
Okay.
felt afraid. You can't even
Mm,
imagine, I sit in one corner of my room crying every day, every single day I came back, I started crying
mm,
sitting in one corner of the room. It's every minute by minute. I wanted to shout out to whom I can say, how they put this kind of allegations to me, how I have to survive my life with these allegations, how I live my life, how to show my face to the public. How this is what
Yeah,
the trauma that I
that's
have.
what you have to question. No? Now you are coming in public. Now you can question that to Women and Child Ministry or WCD, NCW, whoever is managing and promoting this illegal terrorism. The Rekha Sharma or Smriti Irani are there, sitting there. Women, they should know your pain. Okay, and you have right to ask, question them. Why? Why this? If you are tomorrow, if you uh, come out of this case, okay, and proved to be false, will they or they have any means to return your reputation, the lost status, your pride, whatever? They should be like a protector of women in India, and you have right to question them. Can you return my lost reputation, status, pride? You have to right to question them. Okay?
See, the problem here is once what I understood is it's not about 498A. Any person who is a grievance, so who suffered, they can go and give complaint, and it's the responsibility of police to put up an FIR and then go everything. Court will decide whether you are actually done the crime or not, and you have to come out of this. This is the entire process that has been designed. Now, whatever you are saying, that question has to be done, all that it is I can able to do only when I come out with the clean hands. So I'm just waiting for that moment when I come out with the clean hands, and I'll ask, what is that justice that you will give it to me now, undergoing all this pain, being a
Hmm.
woman in the respectable
Yeah,
position.
you will be successful and come out clean because you have not done anything wrong. Okay? You should be
I
clean,
have
come out.
not done
eh,
anything wrong,
Yes,
and
that's what I'm saying. That's what I'm saying. You will be out, come out with this clean hand, and you can prove the society that you are not wrong. Okay?
correct. Yeah.
And all our support is with you. That's why we are hosting you today. You have any thing to say how My Nation Hope Foundation help you?
See, let me clarify. So the initially before my nation itself, there are some couple of things, Sahodar, or I didn't even remember men's welfare. This kind of groups I have joined, but then I don't know. Somehow I felt that as a first instance itself, I felt that as they are trying to get the money. For some reason, I don't know, after joining into my nation, I didn't get that feel of getting extracting money from this false accused persons. Maybe I don't know, I have not undergone this experience personally in my nation. And the second thing what I have is, see, the knowledge, the discussions that has happened, I created some of the friends in my own native place only, and in my state basically. So that's where I started gaining knowledge from the groups whenever there is an issue. See, let's say police, I don't have much things. Once the moment the charge sheets are submitted, I have to go to court. From that point onwards, it's been like 2 years now with the My Nation connection. It's from 2018. So whenever there is a question, there is a concern, I just posted the question in the group and I got the answers. And personally, what I have created a couple of friends also from My Nation. So I used to call them directly and ask them the questions. So they used to answer me, do this kind of thing, do that kind of thing. So the basic knowledge that I have gained from this is the complete legal procedure, and how we women can go and file easily 498A case. And the second thing is the TEP knowledge that I gained from this group, and RTI knowledge that I have gained, and 65B certificate knowledge that I have gained, Indian Evidence Act. So this is the main things that I gained knowledge personally. And it's not that I gained knowledge, I actually implemented that in my case. I collected complete evidences for my case. What is that allegations, what is that happened, everything inch by inch, sentence by sentence evidences I have gathered from after gaining the knowledge from Indian Evidence Acts, and especially 65B electronic device certificates. And second thing is, yes, I am successfully able to file the TEP. I have went and met the government officials. You can't even imagine, I went to Hyderabad personally for meeting that higher official in the uh, what do you call, um, the income tax
Income tax
department.
department.
Yes, I went
Okay.
to that level also. I called up MyNation people that I'm going here, I'm doing this, I'm doing that. Every time I'm posting a question that this is what happened, this is what the RTI reply came in. I don't even know how to write an RTI, but after joining this, I came to know what is RTI. The RTI Act, I started reading, Indian Evidence Act, I started reading. So I can't express so much knowledge that I have gained from last 2 years, and at the same time, that I'm able to implement it. Yes, I had that um, fireback moments also, but still I feel that it is good experience for me in terms of knowledge gain and how I molded my case, and how I can go forward. That path I can able to see from this experience that I have with the my nation.
Okay. Thank you. And one last question before we conclude this Men Ki Baat with along with our sister. What is the message? What is the message you want to give to our system? Or what changes you expecting from our legal system and law ministry and our Indian work?
Okay, so first thing, before giving some conclusions or something like that, I myself framed these questions running in my mind. What is this law has been made? Why are we suffering? All these questions. So before coming to conclusions, myself has some question and answers, and then only I came to this conclusion. So first thing is, why women centric laws are made. It is made initially earlier generations, they have there have been harassments earlier for especially for daughter-in-laws. So that is like previous generation. Now with the technologies it has been changed now. So the same laws, it should not the question was, women centric laws are made to protect women. I agree. Next thing is it protecting women? Yes, definitely it is protecting women. But the problem here, for the conclusions that I'm trying to derive from this question is, now within the this period of time, with so much of advancements, even the people's mindset has been changed. It's not that earlier daughter-in-law means she's like a slave at home. It's not like that. People mindset has been changed. She is identified, she is recognized, and she has given priority in the family. She is a family member, she is not a slave in the house, right? That mindset is also changed these days. Now with this realization, now we have to see why the misuse is being started, because of some personal egos or the money extortions that they wanted to plan and then come in. There are some cases, right? Like a woman will just get married to two three people and then file false 498 on one person, second person, third person. She'll keep on going this cases, and because of fear of woman laws, they'll try to settle money, and she'll go and file for some other second husband, third husband.
Yeah, it's
So
to make
this
money.
correct. So this misuse, we have to understand that okay, the importance of the woman is there these days, especially the daughter-in-law, and the misuse is being there in this. So it is actually a destroying Indian families rather than uniting the Indian families. See, nowhere if you file 498A, she is not going to come back forever, and that relationship itself is gone. Now the family is completely ruined. There is nothing that the family is there, and we feel that it is protected, but it is actually family itself is ruined. So this mindset people has to understand, the system has to understand. System means everybody, including everybody, even the judges, lawyers, system, police, everybody. I would say system means it's a complete um, people living in India. So basically, I'm not against the law. Law is good, powerful for women, but when there is a misuse, please provide provisions, amendments created for the misuse of this. Let's say what I want to say is, people, there are enough laws for women protection, correct, I agree, but there should be an amendment, there provisions. If there are any false cases, there should be reverse punishment. Now in the law, what they will say, accused who is guilty of crime should be punished. perfect. This is very perfect, that accused has to be punished when it is proved guilty. Now at the same time, accused who is not guilty, right, they also get this justice, right? They have undergone malicious prosecution, entire trauma they have undergone for many years. And in India it's not easy that you settle a case in 1 2 years. It will go minimum 3 4 years or 5 years, 10 years, that God knows. But definitely it will go for 3 4 years. That's my personal experience. So this much of time duration that they have undergone, so it has to be, they also get some justice, right? How that, that provision has to be there. See, now people will say,
Okay.
okay, there are
Okay.
some
Yeah.
cases that you can file malicious prosecution, criminal defamation,
Yes.
civil defamation, but the question here is, how many judges are accepting this one? How free our system is, that you easily file this kind of cases when compared with 498A. So it is very easy to file 498A, but we have to struggle like anything, left and right, to file one criminal defamation or to file one malicious prosecution, one perjury case, one civil defamation. How many are accepting? They put so many
Yeah, no, they
points
are
there
not
to reject it.
accepting that. That's
Correct.
make
So
women to file these false cases. That's what
my
we want
my
to
my
convey this message.
my request to this system as such is, there are women centric laws, please go ahead with that women centric laws. I'm not objecting that, but if there is an accused who is especially matrimonial disputes, please provide some amendments for the laws, so that even there are other side of the coin who are suffering with this, let them give justice to them also, let them have their cases to be filed and give justice to them also, as you are giving for the 498A. Give justice to them if they are
And
not
there
proven
should be punishment
guilty.
for those who
Correct.
misuse.
Correct. Whoever is doing
Okay.
misuse, that's what I am
Yeah.
trying to say. The whole point is that give some provisions for them, get them justice, means it is
Yeah.
indirectly is giving
Okay.
punishments for them, right? So this is what
Yes.
my conclusion I would request for the system to have. And thanks all for this thing opportunity to give. I had a lot of things to talk about, but the point, the whole
Yeah.
system that I want to came out here is
Okay.
to show that what the face of 498A on the other side of the coin. Please see the other side of the coin. Let's not go with the biased nature. And daughter-in-law
Okay.
is not an innocent
Yes.
these days. And crime is gender neutral. It is gender neutral. Please don't bias with this. Please see other side of the coin and give justice to them also. They are also human beings.
Okay.
They are also
Yeah.
have
Yes.
their own life.
Yeah. Thank you,
Their
madam,
life
for your
is good.
time spending with us. Thank you very much. We appreciate your cooperation and all the feedback. Hope our legal system is listening to us and they will change and they will make laws generally equal. Okay.
Correct.
Um, uh,
Thanks so much,
with this,
Rudy, for this
yes, yes,
opportunity
yeah,
giving to me
yes,
to come
yeah.
and speak
Thank
on
you.
live.
Yes. With this, we are completing our main ki baat. Dr. Vikas Singh, please continue with our next session. Dr. Vikas Singh.
Thank you, Rudy ji. So
Yeah.
today our speaker
Okay.
is Mr. Raghav. He is a software engineer and law student, and he is fighting the gender bias laws and system. In this study, he took up the study of law. He is going to share his learning experience about legal issue which men face and possible choices which each one can make. So today he is going to discuss about Indian Evidence Act.
Hello, hello.
Yes,
Hello,
Raghav.
sorry. Welcome, Mr. Raghav. Mr. Raghav is a software engineer and law student, and he's fighting against the gender bias law and system. He took this fight to study the law. He is going to share his experience about Indian Evidence Act. Before he gave the same seminar webinar on the Indian Evidence Act, but this will be the detailed webinar on the Indian Evidence Act. So please welcome Mr. Raghav. Thank you.
Uh, Thank you, Vikas. Thank you, MyNation, for the opportunity. So we are continuing our part two of the Indian Evidence Act. In the part one, we had dealt with the history and few relevant portions of the Indian Evidence Act. We went to the definitions of what is a fact, what is a proof, what is a presumption. Then we went into relevancy of facts, which facts the court can take on record. And now we will go into the other aspects of the Indian Evidence Act, which is about proving those facts. How do you prove those facts? There is something called oral evidence, documentary evidence, and burden of proof. How a person who is accused, uh, does he have the burden of proving his guilty or innocence? What are the presumptions a court can make? Uh, Estoppel is talks about how can you stop someone from uh, going back on this thing. So we will go more detail into in each of them. So like we right now we are at 7.5. Let's see how much we can cover. So in the previous session, as we have spoken about, we spoke about how to bring a document or a fact onto record. So under section 5 to 55, we have that. But these are only documents which are on record, but these have to be proved. So these you have brought them on record, but these have to be proved so that this can help you to either prove your innocence or prove that you are accused by the prosecution. So what has to be proved in the relevant facts which you have put on record? One is facts which are not need to be proved. They are proved by default. The judicial orders, for example, a person here who has already got a maintenance order in 125. Now he gets one more order, one more suit of DV. So can he use the order in 125 in DV? Yes, he can. So there is no uh, there is nothing to prove about that order because this has been already going through the judicial process. They are admitted automatically onto the record and they are considered as a valid proof, and the judgment can be made accordingly. Then facts which are admitted. Let us say in a maintenance case, the spouse accepts that I work at so and so place and earn so and so. So that is enough to court to understand that the person has admitted his own in or his or her own admission that she is working and she is earning. Now this can be used for the purpose of the maintenance. So these need not be proved here. These are already proved and by their own admission. Now there are some other facts which have to be proved. They are how can they prove? One is through oral evidence. Oral evidence is nothing but a person you bring onto a witness stand, and he being the primary witness of the allegation or of the event which has been put in the plaint or in the FIR. So he is a witness to either support you or go against you. So the oral evidence must always be direct. It has to be direct. It cannot be someone else saying, okay, I heard that person insulting that woman like this. No, that is a hearsay evidence. It cannot be used. We'll go into the details of hearsay evidence as well. All facts except the contents may be proved by oral evidence. So, for example, if you have a document, you have a registered document between a man and a woman or a contract which you have signed, you can only prove that this document is registered through oral evidence, but the contents of it means I have given you so much, I have taken so much, or this is a contract under consideration of so and so. Those things you cannot prove through oral evidence. Those have to prove through the contents in the document. We have documentary evidence as well. Documentary evidence again has two types: primary evidence and secondary evidence. So when you say primary evidence, so those are the direct evidences. Those are the original copies. Those are the real things which court requires to prove or disprove a fact. So most of the times in our recent world, we are using WhatsApp, Gmail, Twitter. These are the electronic means through which we are communicating. And then so we are actually registering all our transactions, all our conversations. So these are the primary evidences for any of the case you are trying to prove using them. So the original document and the content must be proved. Okay, first of all, you have to bring that document. You have to make sure that the court admits it because it is relevant document. Once you have the relevant document, you have to show to the court these are the things, or these are the transactions in this document based on which I am trying to prove that this case is either false or this case is either true. For example, simple document evidence is salary certificate of a spouse. You take it and produce it before the court because that is a certified copy from the office of the spouse. Now the court has to accept it because it is a primary documentary evidence to prove whether the person can get maintenance or not, or is he eligible or not, or the quantum of maintenance. There is something called secondary evidence. Secondary evidence comes in place where primary evidence is not available or not possible to get, or it is so voluminous that you cannot bring. So secondary evidence is a proxy to primary evidence. Okay, so always have primary evidence, but secondary evidence is also accepted by the court in certain situations. And there is something called public document, private document. So anything, for example, a marriage registration is a public document. Birth and death registration is a public document. Uh, so these documents are written by a public functionary as part of his duty, and every person is eligible to get that document on payment of fee. We'll go into that as well. So, so I just gave you a summary of how to prove a relevant fact. Some facts are already proved. Uh, some facts need to be proved. Those facts which need to be proved can be proved two ways. One is oral evidence, other is documentary evidence. So facts admitted need not be proved. Under Section 58 of Indian Evidence Act, if any party or agent agrees, admits before in writing or by oral, it is deemed to be admitted. For example, in a maintenance case or in a criminal case, the accused goes and says, I was there at that point of time. That is an admission of that person. So that part need not be proved at all. It is already admitted. So anything other than that which he or she claims has to be proved. This is one of the most important things. So in your written statements, uh, either in the counter or your where you actually write a counter to your plaint or a application, you should specifically deny all the allegations. If you don't deny any of those allegations, they are deemed to be admitted. So remember this. So read your opponent's petition carefully. If you don't agree with any of those statements, specifically deny them. If you don't deny, the court will presume that those events have happened and it will take them as fact. Then, in criminal cases, there is a slight variation because in criminal cases, a person has to be put behind bars, that is, his freedom, his fundamental rights under Article 19 are curbed. So, under criminal jurisprudence, there is a stronger reason, that is, proof beyond reasonable doubt has to be there to convict someone. So, it is not just if the accused says, no, I was there, that doesn't mean it is totally admissible. You cannot just rely on his admission. So, if the admission is also there, but still the prosecution has to prove the guilt of the person beyond reasonable doubt. But let us say if the accused has taken a plea of guilt, meaning I say that I have committed a crime, then the proof for that is dispensed with. So it need not be proved. So always remember, never admit anything which you are not sure of. Deny everything which you are seeing in the complaint which you are not agreeing with. So now let's come to oral evidence. How we use the oral evidence to prove that our facts or our documents are correct. All facts except the content of documents may be proved by oral evidence. All facts, whatever you put on record, has to be proved by oral evidence except for the documents. Oral evidence are confined to words spoken by mouth. They have to be spoken through mouth only. If they are worthy of credit and there is it is sufficient without any documentary evidence to prove a fact. How do you determine the worthy of credit? So your lawyer or your advocate or you yourself has to question the credibility of the witness who comes onto the stand and gives an evidence against you. You have to discredit it. Only once you discredit him or his proof is not accepted by the court, then only you will be able to remove that evidence from the record, or it cannot be used to determine the guilt of the person. So it is not so easy to actually put a guilt on someone. Okay, you have to make sure. See, this is where the lawyer has to play his part. He has to make sure that first of all, no documents should be admitted which are not part of the which are not relevant to the case. Next, each of those documents which are taken on record have to be tested thoroughly. Means they should not even be put once they are put on record. They have to be thoroughly questioned so that the witness is sure that he is not telling any lie. Then the last thing is written documents are best evidence of their contents only. Only contents. No oral evidence can be adduced to prove them. You cannot say that I have seen him writing so and so document in which he has asked dowry. No, that is useless. That is hearsay. It cannot be used. Coming to an aspect of oral evidence, hearsay. Hearsay is like a third person. Let us say uh, there are two parties, A and B. A is the father of the bride, B is the father of the groom. And now there is a C person who happens to see that A giving some dowry to B. Now C is a direct witness. He can come to the court and say that he saw that A is giving witness, A is giving dowry to B and B has not received dowry. Now, but there can be some X to whom C has listened to, who has listened to C, saying that, "Arey C, A ने dowry दिया है B को, I have seen it." Now X cannot come to court and say C has said that he has seen A has come and given dowry to B. That cannot be used. Forms of hearsay can be written and spoken. The one example I've given was about spoken. Hearsay is not admissible to establish any evidence. Why not admissible? Let's understand. It is totally weak evidence. It will bring a question into mind of anyone of the existence of fact, and frauds can be practiced on that. I can tell any lie. I can say that person told I don't know. So it is basically liable to be fallacious, misunderstanding. So he might have understand something totally out of context what the actual situation might be. It is totally inaccurate. And sometimes some people wantedly pervert it. They actually try to create a situation where things go wrong. And the most important thing is the person who is giving hearsay evidence cannot be prosecuted to perjury because he will just say, he told me, I did not say anything. So how can you put perjury on the person who is giving such kind of evidence? And it greatly increases the expenses on the public exchequer and it's vexatious. And it can also create multiple collateral issues which are not relevant to the matter also. So you are basically losing the sight of the main question. So remember, when you are having your witnesses brought onto the dock, if the person is not direct witness, you have to shout on top of your voice that he is a hearsay evidence, he should not be admitted, and his statements should be removed from the record. Now, there are exceptions to hearsay evidence. Not everything cannot be thrown away. So we have something in section 17 to 39 where there is some relevancy. We have already discussed it. And there are some admissions and confessions which we make. For example, someone has, you have admitted something and the witness also corroborates it. So that is an exception because you already collaborated with them, so it cannot be removed. And certain statements of a person who is dead, for example, Section 32 of Indian Evidence Act, a person who is dead and he has a dying declaration, he cannot come back onto the stand and say, I was killed due to, by this person for some reason. So there is an exception for it because he cannot come back as a witness. And it is also considered that on the dying bed, person generally speaks truth. It's a presumed. Again, previous depositions of witness. See, in India, we have cases running for 50 years, 60 years, and some 498 cases have been running for 20 years. In all this lifespan, people die. Okay, but witness statements, witness can also die. So in that case, the statements of the witness cannot be considered as hearsay. They have to be put on record. Entries made in book in due course of business. If a person is in a business and he makes a regular entries, it is assumed that those records are not fudged in regular business. Like for example, banking transactions, those are regular transactions. It's very hard for someone to fudge them automatically because there is a ledger which is getting listed day to day. Every those kind of things happen. Rule of best evidence. This is one of the primary thing which is used to prove or disprove any fact which is brought onto the record. The cardinal rule is you should always bring the best available evidence. Why? So generally lawyers are smart. What they do is they don't bring the best evidence. Why? Because if they bring the best evidence, there will be a part in that evidence where the guilt of the accused can be not found. For example, the example I've given previously, where the person A, who is the father of the bride, has given money to person B, who is the father of groom. The lawyer will say B has demanded money. He won't bring the witness C to the court because if he brings that witness, his case is gone. So, first thing, whenever you are in a court, always try to bring those relevant people or relevant witnesses for your case. If that is not done, then you can always ask the court to summon those people or summon those evidences or summon those records. Oral evidence must always be direct. We have understood why hearsay is not valid. Documentary evidence must be proved by primary evidence except when the secondary evidence is allowed. Primary evidence, if the document is there, the document is good enough proof for us to actually go to the document, read the content, and understand what are the contents of the document are. And that content has to be original content, not some Xerox copy. Yes, secondary evidences are allowed when that document is not available or not possible to procure or it is not movable. In such scenarios, secondary evidence has to be corroborated again. It is not that secondary evidence cannot in itself can put someone accused. Accused. Then 91. So section 91, any contracts. So this is very specific to civil procedure where uh, everything which is in nature of agreement has to be put in writing. It cannot be oral at all. That helps reduce the litigation. That helps reduce the confusions. Coming back to documentary evidence, till now we have completed oral evidence. Coming to the documentary evidence, proof of content of the document may be proved either by primary or secondary evidence, which we spoke of. Primary evidence is document itself produced for the inspection of the court. The court has to inspect the document. That is the original document, nothing else. Documents made in one uniform process is the primary evidence of the content of the rest. For example, you have a huge document, but it is made through let us say you are printing 100 pages from a printer. You produce the first 10 pages in the court. The remaining 90 pages are also primary evidences because they are produced from the same printer. These 90 documents are part of the same document. So they are also considered as a primary evidence for proving the uh, fact which you brought out to the record. Xerox is not a primary evidence. When you put a Xerox, you have to again satisfy the court that the contents are not altered, the document has been produced in a proper way. So that becomes a secondary evidence. So why primary evidence is so important? It gives you greater certainty of the fact in question. So what are we trying to decide in a case? First, we are trying to decide the fact in question. Whatever the allegations are they actually true? For those to be proved, you need some facts, and those facts have to be proved, and that proof should direct you to that allegation to be proved or disproved. So only primary evidence can give you that certainty, not hearsay evidence, not Xerox copies, not secondary documents, only primary evidence. But there are exceptions to those rules, but all these exceptions are governed by certain procedures. Secondary evidence, uh, under Section 63 Indian Evidence Act, it has confined what can be secondary evidence to 5 categories. Certified copies. Certified copies, for example, in court, you can get a certified copy of your document. That is, it's just a copy of your original, but stamped with saying that this is a true copy on brought on so and so date from so and so office. Copies made from the original, which ensure that accuracy of the copy. So, without altering the copy, if you are able to produce a document which is original, again, these kind of documents have greater requirement to prove. Whereas certified copy doesn't require greater, so it becomes a public document and it has a uh, lesser degree of test. Counterpart documents are nothing but the same, if you have 10 documents, only one document, other 9 are also coming on the secondary evidence. Oral accounts of documents who have seen the document, we have discussed this. Sometimes it happens that, let us say you make a will of a person, but the will is lost. So one person comes and says, I have read that will, so these are the content of that. But that is a secondary evidence only. So it has a less weightage in amount which can be used to convict or put the case in the favor of the person who has filed it. Secondary evidence. When can secondary evidence be brought in? When the original to be shown is in possession of the OP or the other side who are not willing to provide you, or it is lost. Original is destroyed or lost and cannot be produced within a reasonable time. See, court has a limited time. We have to live our lives also, right? So, court, for example, a person has gone to US with some documents. He is not able to come back to India or not able to provide that document back to India due to lockdown or flight restrictions or whatever. Court cannot wait, or the court will just take some time and decide. Okay, the reasonable time is done. We can still move forward with the secondary evidence. Original is not easily movable. For example, whatever we do today on social media, Facebook, Amazon, um, WhatsApp, these are in external data centers which cannot be moved. There is only one copy with you that you can bring to the court, but these are actually stored in an external servers and external data centers which cannot be moved easily. So, secondary evidence for those documents are allowed. And original in public document. So, public document is any document, again, so certified copy of a public document can also be a secondary evidence. Uh, if the original consists numerous documents, if you have like thousands and thousands of pages, so court will just say, give us a pen drive with all those documents. That should be enough. Electronic evidence. This is one of the most what contentious thing which everyone is having in mind. So first of all, it's a secondary evidence. Okay, because you don't have the original with you. If you have the device, for example, if you have a mobile phone through which you have taken a photo, then if you produce the mobile photo, so mobile phone, then it becomes a primary evidence, and you know it doesn't come under the electronic evidence. You have directly given the device there, so the court can examine that device. Second, there is a certificate called 65B. So the 65B has few things. Basically, it says the document is not tampered, the device is regularly used, the device was normally operating when such thing was recorded or the picture was taken, and it has no effect on accuracy of the content. So 65B just says this. It doesn't say anything more. The purpose of 65B is to satisfy the code that the electronic device which you used was not tampered with. So recently, the Supreme Court has made it mandatory, as per its latest judgment, any electronic evidence which you provide has to be have 65B certificate. For example, an email conversation. You take a print of it, it has to have a 65B certificate. So there is a standard template which is available on MyNation. You can take it from there. Uh, this is necessary for admission of all electronic evidences. Exception: such certificate, if it is not obtainable due to the possession of original is with the opposing party, or it is practically impossible to bring that records within certain time, then you have to satisfy the court why you are not able to provide the 65B certificate for such particular electronic device. If you are able to satisfy the court, that evidence was also put on record. Certified copy, I just wanted to give more details on it. Under section 76 of,
Raghav, we
sure,
have some
sure.
questions. Can we take them now?
Yeah, definitely.
Yeah, I think is related to 65B. So the question is, what if a phone call conversation is recorded and over a period of time, phone went into bad, unrecoverable state? Copy of calls are stored and backed up in a computer. So the original device is not available, but the soft copy is retained in perfect shape. So can that be presented, and what other evidences are required along with it?
So first thing, if you have the old phone, you have to produce that old phone also, because through FSL, forensic lab services, forensic labs, you could actually recover the data. Second, these days we are using cloud services like Google Cloud, Microsoft Cloud, where we always back up things. So even in that cases, there is a digital signature for each and those records. If you are able to prove to the court, see 65B certificates only admission. It's not about the content of the. Uh, it doesn't go into the content of the record. It only goes into the admission of the record. It only says if this document has not been tampered with or not. That's the only thing 65B does. It doesn't go into the content. So you could try to bring that record onto the court's notice. Court will decide. Generally, they have to accept it unless they find one of the provisions of 65B has not been satisfied with.
So
Ramesh?
the content copy is actually available. The phone is actually not in a working condition now, but you say that the phone has to be submitted to the court, and if at all if there is a possibility, they will retain the data from the phone itself, or else we can actually submit the soft copy which we have preserved.
Yes, we have to submit. Yes.
Oh, we have one more question. I think is related to the FIR. How do we deal when you want to get the FIR, but CWC cell is actually forcing for settlement? Seems the case is actually in that very initial stages where FIR is filed, the complaint copy is not yet shared to the alleged accused, but they were actually forcing them to come and compel them to force or for settlement.
Okay, first thing about CWSL, no one can force you to settle. Even if they ask you, that is not uh, it is not what you call it, legal, or it's not something
By
you
law.
can valid. It's not a valid or legal thing bind on you. Second, FIR can be brought multiple ways. One is you go to the court directly and get the copy where your police has registered. So every FIR in within 24 hours has to go to the court where this case would be trialed later. So go to the court and take it, or go to the police station and take it, or file RTI and take it. Every accused has a right to have his FIR. So there are, I already told you three ways. Your advocate
Yeah.
can go and take. There are like in some states, online FIR is also available. You can check on that. Yeah,
Okay.
that's
We have one more question. Is the evidence from social media accepted? Let's suppose on the social media they have posted something, and it has been even deleted later, but yeah, the copy of it and the state when it was posted might have been captured. So can that be
yeah, that is
submitted as
totally
evidence?
accepted. Yeah, that is submittable. It is accepted.
WhatsApp messages in original phone, can they be used as evidences?
Yes, they can be used.
Okay.
Like recently in Delhi, the Delhi riots case, all WhatsApp messages have been used as an evidence to put them behind bars. The state is doing it. Why can't you?
Okay. And the audio records of phone conversation, can they be directly presented to court that have been recorded without the knowledge of the persons
We can
who are
provide a
involved?
we can provide a stolen document to the court also.
Okay.
Stolen
So,
document. You have to just satisfy the court how that document is relevant for your case. That's all. It is
but not how we
immaterial.
got it.
No, it's not. So that is the beauty of Indian, yeah, Indian criminal system. I mean, that is, I feel that is really important also. For example, where power structures are so strong here, you can see the Tehelka case where you brought out records through sting operations. So it is acceptable. The Nira Radia tapes, for example. Is there one more question? Should I go forward?
Yeah, just in continuation to the earlier question, let's suppose if the device is actually not available, can they simply provide the preserved copy saying that the device is actually not available now? And in those cases, what else it has to be complemented with?
So first of all, electronic device is a secondary evidence. Electronic
Okay.
evidence is secondary evidence. Okay, secondary evidence cannot be the sole basis for any conviction or any release. So you have to corroborate it with other evidences also, like other oral evidences or other documentary evidences also. Means you can use, or you can use any other electronic evidence which has a proper certificate, and if that corroborates with this particular electronic evidence which you don't have the original device, or if you are not in access of those documents, those can be used as a corroboration and your proof can be strengthened.
Yeah, agreed, Raghu. I think you can continue now.
Yes, certified copy. This is very important because I am talking even from the perspective of RTA also. Certified copy. Every public officer who has a document in his custody shall give that to a person on demand. Remember, on demand. He has to ask it on a payment of legal fee, and on the copy he has to put the certificate at the footer saying this is a copy of the truth, and such document has been made on so and so date. So for example, you go to a bank, you want a transaction statement, they will put a stamp underneath it with so and so date and signature of the authorizing authority. Because government officers are doing public, those are public functionaries. Even the communication between two departments also you can get through certified copies. So RTI has made it more easy to get those documents. And certified documents are secondary evidences, but they need not be proved. They will be presumed proper proofs. So, uh, generally, primary evidences are direct evidences. They need not be proved. Only their content needs to be proved. Secondary evidences are proxies of primary evidences, but they need to be corroborated. But exception to those is certified copies. If you get a certified copy from an authorized bank or a public functionary or from the court, then they need not be proved because they already have been done in the process which has been written for them. Uh, Again, in the name of the public officer, seal, everything has to be done. It shall be admitted as secondary evidence. That is the beauty of certified copy. Um, yes. Again, the others have to be proved. This need not be proved. Section 74 and 75, public document, private document. Documents which are like acts of any sovereign authority, any official body, tribunal, legislature, judiciary of any part of India, Commonwealth, or foreign country. Even a foreign decree or a foreign document is a public document. It can be put into the records of the court and they will be taken on their face value. But those have to be given by the sovereign authority, that is governments. Public documents is prepared by a person in discharge of his public duty, available for for a fee. Bank records are public documents, hence admissible without any further proof. So you do not bring the banker saying, "Arey tum aao, like you have given me this document. Now the court is asking me to come and show me the person who has given this record." No, it is not required. Bank records are taken on their face value, but there is an exception. The police Panchanama report of an unnatural death, it is not a public document. They won't give you. There are certain small exceptions which we'll not go into because these are not relevant for us. So court is bound to believe the genuineness of those public document. So we will see in further in section 114 where court can make certain presumptions in absence of certain facts. We'll understand that. Burden of proof. This is the crux of the whole Indian Evidence Act. One is admissibility of a document, that is bringing the document which is relevant to the question in fact, then proving the document, then who will prove the document, who, the burden of proof is who. The burden of proof lies on the person in whose favor the judgment he wants, his legal right he wants to protect. So he must prove that fact. It is his responsibility to prove that fact. If he is not able to prove that fact, then he will be on an adverse position. So in criminal cases, burden is always on the prosecution. Criminal cases, burden is always on the prosecution. That is the state. But there are certain small exceptions. By default, in our criminal jurisprudence, all the criminal cases have to be the burden of proof lies on the prosecution. But in certain cases, like Dowry Prohibition Act, DP3, DP4, where dowry giving and taking is a crime, and Section 376, uh, where there is a rape case or POSCO case, there the burden of proof is on the accused to prove that he has not done such kind of things. But the quality of the burden of proof is very less. We'll understand that. Uh, in criminal cases, the prosecution has to prove beyond reasonable doubt. Beyond reasonable doubt means the court should not have any other choice. It should prove that that is the only possible thing a man with proper intelligence can understand. It is not court has a different mind and we have a different mind. A common person, if he sees all those facts, he should say that okay, this guy did not do that, or there is no chance that this person has done that. That is reasonable doubt. If in case of accused where the burden of proof or onus of proof is on him, so for him, the because in criminal jurisprudence he is innocent until proven guilty, so he has a degree of uh, less degree of proof. That is, he just needs to create a doubt in the mind of the court. There is a situation, there are two possibilities which can be possible if he is able to bring that situation. For example, A says he has given dowry to B, B says A has given dowry to B. Now, if B is able to prove or bring a doubt in the court saying that I have not taken dowry, but he has given me the dowry, whereas he has not proved totally, but he has brought a doubt in the mind of the court, saying there is a situation where A has given the dowry, in spite of B not taking it, not asking for it. So that is good enough for the person to relax his burden and shift the burden again to the prosecution. Now, in DP3 case and DP4 case, where DP4 case where the person is tried for taking dowry. Now, if he can prove to the court saying that, sir, these are the bank records, these are the transactions which I have made. I have given them money. Rather, it's not they who have given money. I have given the money. Now, when you are able to prove as a person against whom TP4 is there that you have given the money, where so you have raised a doubt in the mind of the court saying that you have not taken the money, but rather you have given the money. So, where is the scope of you taking the money? Even if you take the money, it has to be recorded somewhere, right? Rather, now you are actually giving the money here. So you have created a doubt in the mind of the court. Now the burden goes to the prosecution, the state. Now it has to prove, saying that why did you take money? Why did the prosecution take money from me? They will give all those reasons. Now, by this time only, you have already proved your case that it's false. So you have to create a doubt in the minds of the court. In civil cases, for example, the your matrimonial cases, property cases, it's only preponderance of probability. You just need to create doubt again in the mind of the court, saying that no, this is not the possibility. What I've told is the real thing. So that is what is called reverse burden. If a person against whom the case is there, but he is asked to prove his innocence, that is a reverse burden. But that burden is relaxed by saying that it's only preponderance of probability. He just needs to create it out in the mind of the court. Onus of proof. We have shifted the onus of proof. For example, in DP3, DP4, we already said the onus of proof is on the accused. In POSCO case, the onus of proof is on the accused. But even for that onus of proof to be put on accused, the prosecution has to establish the fundamentals, saying that these two were married. If these two were not married, how does the DP3, DP4 case come into existence? Or even before DP4, DP3 and DP4 can be raised even when you are not married also. In that case, if you are able to show to the court that in all these discussions, there was never a question of, so these two were never in a relationship. It means there was never a marriage planned between these two people. The prosecution has to establish there was a plan of marriage between these two people. In that process, this person has asked for dowry. Then only the prosecution has established the foundation for dowry on accused. Now the accused, to shift the burden of proof onto the prosecution again, he has to say what exactly has happened. He has given the money, or they were just discussions, or they were gifts proposed by the bride side towards the bridegroom, or they were gifts for the bride themselves. So these all details will go into. So the onus of proof is again shifted back to the prosecution. And general exceptions, we have discussed in the last session where there are certain general exceptions, like the person is a child, the person is in inebriate state, or person is uh, private defense. Let us say someone was hitting him, so he had to hit back. So there are certain general exceptions. So to invoke general exceptions, you have to the burden comes on you saying why should the general exceptions uh, apply to you. So you have to prove to the court saying that on that day had been hit with something, so I was not conscious, or someone hit me, so I had to retract back. That is the reason this case has been filed against me. So burden of proof is very important. Uh, Legitimacy of a child. This is crazy thing which I found in Indian Evidence Act. So it's very important actually. It's not crazy. Sorry to say that. So the child's paternity is in question. So the courts have been very considerate so that the child who is not at fault for his birth should not have any infamy or any wrong treatment in his peer group or in the society. They have made this particular section 120, 112 of the Indian Evidence Act. What it says is any person born during continuation of a valid marriage between his mother and any man or within 280 days, remember this 280 days after dissolution, the mother being unmarried, shall be a conclusive proof that he is a legitimate son of the man. It is easy for a woman to prove that the child is hers because there is a direct inference because the child is born from the womb of a mother. Whereas the father is just an inference. The mother has to say that he is your father. Then only he knows or she knows, right? But what is the child's wrong if his mother has done something wrong? So, just to protect the child from these kind of things, they have made sure that if there is no continuation of a valid marriage and the child is born within 120 days of after resolution of marriage, the child is still considered as a legitimate child. But this will show badly on a man who is not the real father of the son, right? He is actually at a loss. So what can he do? It has to be shown unless the part the person has to show that there was no access. Access means physical sexual intercourse at any time when the child was begotten. He has to do that. There are multiple ways to do that. Previously, till recently, courts it was very hard to prove that. Now it has become easy through DNA test or through other means. But court won't easily allow you DNA test because the child's future is at risk. So what you need to prove to the court, stating that you have to rebut in a strong, clear, and satisfying way that from so and so period I was never in contact with her. You have to prove to the court through certain. Let us say you are staying at two different places. You have to provide proofs of photographs or certificates or whatever that is. Then only the court will accept. It's not mere balance of probability. If you just like we have thought about balance of probabilities, right, where you just need to provide a doubt in the court. No, now you have to prove conclusive to the court saying that I was not there at that point of time, and this child is not my child. Now the court will allow you to have a DNA test. DNA test these days is considered as a stronger test over any other kinds of tests. It's prevailing over the conclusive proof. So once you have a DNA test, then you can able to show the parentity of the child. But it has been seen that some women are very clever. When the court orders them DNA test, they don't appear. They don't go to the DNA test. Court has on multiple occasions taken adverse inference and granted divorce to the father or the male person because I'm sorry, there is a whistle. Yeah. So, yeah. So where am I? Okay. The court has considered the non-participation or non-satisfying the court's order as a violation or as a acceptance to the guilt. So some cases have been there where divorce has been granted on this ground of adultery because child is born out of wedlock where this person is not the legitimate father. Uh, Coming, so like these next two sections are very important. Section 113A, where so the court presumes that a married woman who has died within 7 years of her marriage under whatever circumstances, the husband or a relatives of her husband when the death is within 7 years of the date of marriage. And where she has been subject to cruelty, the court may presume. The word cruelty is similar to the word cruelty in section 498A, where a person uh, has a has a threat to her body or mental limb, whatever that is. And the court may presume the husband has and his family has abetted her death. There has to be direct evidence linking such death, and circumstantial evidence raising the presumption has to be proved beyond reasonable doubt. So again, so these abatement, see, the problem with abatement is you get half the punishment as a real death. So let us say the woman dies, so it is like a murder. So you have a punishment up to life imprisonment or death also. So in that case, in life imprisonment, you may get 10 years sentence in abatement. So that is a problem, right? So in that case, you have to provide direct evidence linking the death, and circumstantial evidence is not has to prove beyond reasonable doubt. Court has to consider if the alleged cruelty was of nature which likely to drive women to commit suicide or grave injury. This is the standard 498 clause. So then there is a new provision which has been added, dowry death. If it can be shown soon before the death of such woman, there has been cruelty or harassment, for in connection with dowry, the court shall presume such person has caused the death. So there are three important factors in it. Soon before the death, there has to be cruelty proved. Then that cruelty is in regard to the demand for dowry. Then only the court shall presume such death was caused due to dowry. The accused has to rebut such presumptions. First presumption is the death was not before there was no cruelty just before the death. Second, there was no demand for dowry. These two aspects he has to prove. Here he just need to create a doubt in the minds of the court. Now this is one of the important clauses. Wherever you don't have the facts, court has a discretion to presume certain facts. Court may presume existence of any fact which it thinks likely to have happened in the natural course of action of human conduct. Remember in 112 case, 112 Evidence Act, where the mother doesn't participate in the DNA test, the court presumes that this person is not the father of the child, and so the court can claim that he is not father of the child and can be granted divorce on the grounds of adultery. Similarly, if in dowry prohibition cases, if the person is not able to prove the burden of his saying that I have not taken dowry, then court will presume that he has taken the dowry. So examples. Uh, so first of all, court believes that the police have followed the all procedures and rules. Then only they have arrested you in 498 or 376 or 354. They have followed the rules. It is you have to tell to the court that the 41A procedure has not been followed. They have arrested you at the midnight. They have come to your home. They have searched your place. These kind of things you have to tell to the court. Otherwise, court will never know. Court always assumes that police has done correct. Then evidence is withheld and presume when the evidence is withheld, it will be presumed unfavorable. So we have seen that the best evidence is the evidence which has to be given to the court. It cannot be withheld. If you withheld such thing, it is seen that something which is unfavorable to you, that's why you're withholding such information. Withholding such information. Refusing to answer a question. So many times in cross-examination, we see that some people say don't answer. No, you have to answer, but in a normal way. Either you can say, I don't know, I don't, but you say I won't answer. If you say I won't answer, then court will take it in an unfavorable way. So this is a presumption in the absence of consent. So section 114A. Uh, so we have this 376 rape cases IPC. The rape has two aspects to it. One is sexual intercourse, second is consent. So to prove that rape has happened, you have to prove two things. One is there is a sexual intercourse, and that sexual intercourse has happened without consent. Now, uh, the court can ask a woman, where was her consent taken? If she says that no, my consent was taken, the court will just believe her. It won't question her credentials because it says shall believe, presume that she has not consented. Now the burden, the onus now shifts on to the accused. Now you have to prove to the court saying that no, sir, this woman has consented, or this relationship has been there for long period, or any other factor, or you are not there at all. That sexual intercourse never happened at all. So these are the types of presumptions women are having in Indian Evidence Act 113 A, 113 B, 112, so many. Now we are, Ramesh, do we have any questions or should I go forward or we are pausing on time?
Yeah, please continue.
Yeah, okay. Uh, Witness, we have spoken about witnesses, the oral evidences. Who is witness? All persons are competent to be a witness unless the court considered they are otherwise. How can court consider someone is not a witness when he is not related to the case, or when he is actually disturbing the process of the court, or he is a child below 6 years? There are certain factors. The tender age of a person, extreme old age. For example, today we have corona, so courts are not allowing anyone to come in. So if he has a disease of body or mind or any other cause, he is not a competent witness. Now, I'm bringing this point of child witness because this is very important in terms of matrimonial disputes. Uh, Child witness who is above 6 or 7 years may be allowed to testify if the court is satisfied that they have the capacity to give a rational testimony. So the judge who is there has to actually satisfy himself. So he cannot ask direct questions. Did you see your father hitting your mother? Or did your mother abuse you? No. He has to ask in a very organic way. How was your day-to-day life? When did you wake up? Who used to take you to school? Who used to make you breakfast? That's how he has to ask a question. So in that process, he has to satisfy himself that the child is behaving rationally. He is not under the influence of someone. If the child's witness is credible, truthful, and has to be corroborated, conviction can be based on that. Generally, why a broad child is in POSCO cases. I've seen fathers who have had POSCO cases. Children, especially girl children, have been giving statements with lot of audacity, and they are able to face the court with such a grit that because of them, the fathers are getting acquitted. I thank to all those girl childs for being so brave. So the child's witness is an acceptable evidence to prove a fact, but the court has to make sure it puts all its resources in making the child comfortable. But child witnesses are very dangerous because tender age, easily palatable witnesses, pilable witnesses, and they can be tutored either by threat or coercion or inducement. Children can be said, if you go to your father, I won't give you chocolate. If you talk to him like this, I won't buy you things. So this is how the brains of the child are put under immense stress. So the court has to take lot of time in understanding what situation the child is going through. Generally, all the witnesses have to put a oath statement and give their statement, because if they do any perjurious comment, they can be prosecuted. But child, because he's a child or she's a child, oath is not required. The court has to be satisfied and record its opinion. Again, it has to be corroborated. Always child witnesses has to be corroborated. So we are almost at the end of this session. So spouse as a witness. Uh, Previously, woman was considered, previously, ages back, woman was considered as a property of man. So husband and wife could not give any evidence against each other. Now those days are gone. Husband and wife are competent witnesses to go against or for each other. Next, section 122. This is also one of the important thing. The communication between husband and wife cannot be brought on to record. Let us say, if a wife says to the courts saying that my husband told me that he saw that person on the terrace killing someone, she can those statements won't be accepted by the court, because both are considered one and the same. But in the suits against each other, each of those statements are taken as a competent witness. If you have a 498 case, the statement of your wife is taken. If you have a cheating case, your statement of your husband, of the wife, or both are taken. Professional communication, like the communication between your advocate, those are very privileged communication. They should not be disclosed. They are forbidden from being disclosed without the consent of the client. Exception is when the counsel is made witness. Even there also, there are certain privileges which he cannot go beyond, because with whole trust, he gives those information. Anyone can use that to abuse his position and uh, use it to convict or release a person. So I am ending it here because it would take more time to cover other areas of cross-examination, um, those aspects of it, how to do cross examination and how to find corroborating and circumstantial evidences. That part I am not getting into it right now. Any questions or anything we want to discuss, please go visit mynation.net. You have all the judgments, and kindly be active on groups. That's all, Ramesh, from my end.
Yeah, thanks, Raghav. Actually, we don't have much questions on YouTube, so assuming that they might post it later, we can actually take it offline. I will hand it over to Vikas now. Vikas, over to you.
Can I close the session, please? Hello.
Yes, Raghav. Yeah, you can.
Yeah, it is still streaming live. That's why I'm asking.